for your divine guidance as we have our first discussion. Help us focus our minds and hearts as on what we are about to learn. And this we ask in the name of Jesus. Amen.
Amen. Okay, thank you for that, Miss Ambrosio. Sige, so let's start. Can you see my presentation?
Yes, sir.
Yes, sir.
Sige.
Yes, sir.
Okay, let's start. So, this is not the first time you've heard the word partnership. The earliest form of partnership was, kaya lang may nag-join. Okay, sige. So yun na, let's go back. The earliest form of partnership was sole proprietorship. Of course, it started with an individual business. And then with the limitation of capital and income and potential of a business, people tend to improvise. And noon, early times, bago pa lang yung partnership. So, it gave them additional capital, additional experience, and it allowed them to secure economy and eliminate some expenses because of forming of capital. So, I will not give you a lot of background regarding this one kasi I know yung subject nyo before sa lower years nyo sa BA, I think na take up nyo na yung forms of business organizations or proprietorship, partnership, corporation, cooperative, and the like. So, what we are going to look at is the legal basis of partnership. So, ang partnership under the Philippines nag-start under the old civil code which is rooted from the Spanish law. Okay? And along with this Spanish law, nagkaroon din lang Uniform Partnership Act and Uniform Limited Partnership Act. So kung iintindihin natin ang partnership, we have to look into these laws. Kasi yung partnership na alam natin ngayon, doon sila nanggaling sa Spanish law at sa American laws. So, huwag kayo magtaka if may mga cases later on na pertaining to cases na hindi sa Philippines, na sa Spanish law pa or sa American regime pa, kasi doon lahat nanggaling. Okay? So, that's a brief background of partnership. So, let's go to the first article of partnership. So, dito pa lang sa unang article, there are two interpretations. Aside from the two paragraphs that you can see in the slide, there are two interpretations we can get from this article. So the first one is yung first paragraph. By the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. So kung titingnan yung mga naka-bold tsaka naka-underline letters, these are what you call the essential requisites of a partnership. So kung babalikan natin, contract, by the contract of partnership. So ang partnership is a contract. Kung babalikan mo ang obligations and contract mo, meron ka lang konting knowledge sa partnership. Kasi yun ang foundation niya. There must be a valid contract. The first essential requisite of a partnership, there must be a valid contract. Okay, ano ibig sabihin nun? Babalikan mo ulit yung nasa oblikon natin noon. Na ang contract mayroong dapat consent, may object, at may cause. Consent, may meeting of the minds, di ba? Two or more persons enter into a contract. Object, two or more persons bind themselves to give money, property, or industry. Cause, to earn profits and to divide it among themselves. Kung sa-summarize mo yun na yung meaning ng partnership dun sa first paragraph ng Article 1767. Okay? So the second essential requisites, there must be two or more persons. Not just any person. Pag sinabi natin sa law, hindi lang person. Kasi sa law, there are two kinds of persons. You have a natural person and a juridical person. So, ang most probably dyan is natural persons. Okay? Ibig sabihin yung tao mismo. Okay? And also, you have to take note, they have the legal capacity to enter into a contract. Ibig sabihin, age of consent or majority age, which is 18. Hindi 21, 18. Okay? Pero dun sa natural and juridical person, mayroong ding instances na may partnership ang dalawang juridical person. Kapag sinabi natin juridical person, gawa siya ng batas. Gaya ng corporation, juridical person yan. Gaya ng partnership, juridical person. Pag dalawang partnership or dalawang corporation, nag-enter into an agreement, yung tinatawag nating joint venture na tinatawag, there can be a partnership. That's a partnership within a partnership. But hindi muna tayo pupunta doon kasi masyado pang deep yun. So una, there must be a valid contract. Pangalawa, two or more persons have a legal capacity to enter into a contract. Pangatlo, mutual contribution. Yun na yung sabi natin kanina, money, property, or industry. There is no limit on the contribution. Okay? Industry may be physical or intellectual. Industry or service. Okay? And then the fourth one, it must have a lawful object or purpose. Itong number 4, i-relate mo siya sa number 1. Bakit? Ang contract, there can only be a valid contract if the object of that contract is lawful. Di ba? Let's say, for example, you form a partnership to sell drugs or 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 to kidnap kids and then get their internal organs and then you sell them. Although sabihin mo na siguro, kunwari si A, si B, si C nag-usap-usap na mag-enter into partnership, magkikidnap sila ng mga bata. Lahat ng mga kidnap nila, kukuhanan nila ng internal organ na pwedeng makuha. And then, ibebenta yung proceeds dun sa mabenta, paghahatian. Hindi yun valid partnership. Kasi yung object, yung purpose nila is unlawful. Hindi siya lawful. Okay? The fifth one, the partnership must be established for the common benefit or interest of the partners. Of course. Kaya nga, partnership it's for every partner. So there must be a sense of mutual trust and confidence between partners. So, lagi nyo maririnig sa partnership yung tinatawag nating mutual trust and confidence. Okay? The purpose of an ordinary business partnership is for the generation of profit, and the partnership must be established for that purpose. And all partners must share in the profit generated. Any stipulation that excludes a partner from profit sharing is void. Okay? So, dapat lahat may hati sa profit. Kapag nag-partnership kayo, pero may isa na hindi kasali sa profit sharing, hindi siya partnership kasi excluded yung isa. You're not acting for the benefit of everyone. Okay? So those are the 5 essential requisites of partnership which you can essentially get from the first paragraph of Article 1767. So I'll let you digest that. Contract, two or more persons bind themselves, contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. Now, sabi ko kanina, there are 2 interpretations here sa 1767. The second one is you interpret both paragraphs. Ang second one, sa first paragraph, yun yung tinatawag nating ordinary business partnership. If the goal is to earn profits and divide it among themselves. The second one is the general professional partnership or yung GPP na tinatawag natin. Ang ibig sabihin nito, ang goal ng GPP is, basahin mo yung paragraph 2, 2 or more persons may also form a partnership for the exercise of a profession. So, ang general professional partnership is formed purposely to exercise one's profession. Gaya ng mga CPA, ng mga lawyers, doctors, pwede rin. Basta ang main na purpose niya is to exercise the profession. So, yun yung Article 1767. Okay? The meaning of partnership, the requisites, and then the two kinds of partnership. Pero madaming kinds ng partnership. Yan muna, ordinary and general professional partnership. Ito examples ng ordinary business partnerships. I will just continue with the lecture. I will presume na nakikinig kayo. I will try to slow down para naman masabayan niyo yung pace natin. Okay? Kasi napag-alaman ko na may mga hindi makapasok today, kaya unfair naman kung paparecite ako. Ang recitation na lang natin is dun sa bibigay ko na learning task. So, ito na lang. Tuloy-tuloy natin yung lecture. Anyway, heads up, lahat ng nasa quiz, nasa learning task, nandito sa lecture. So, if you can get a perfect score kapag nakinig kayo, lalo na yung mga examples natin. Okay? Sige, continue. Examples of OBP or Ordinary Business Partnership. We have Google, Twitter, Microsoft, Apple, Hewlett-Packard, McDonald's, Warner Brothers. Okay? Because they are generally formed to earn profits and they divide it among themselves. Ito lang yung mga sikat kasi ng mga partnership. Okay, and the second form in general professional partnership is, ito na yung na-explain ko kanina. They are mainly formed for the exercise of profession. Sir, hindi ba sila kumikita? Kumikita sila, pero yung profits nila, incidental. Ibig sabihin, hindi yun yung main na purpose nila kung bakit sila nag-form ng partnership. Ang main na purpose nila is to exercise their profession. Tapos kung may kita, sige, paghatian namin. Ganun lang. Ito examples ng GBP. Sisip Gores Velaya, this is an accounting firm. Punong Bayan and Araulo, another accounting firm. And then for the legal profession, you have Acra Law, Divina Law, Kisumbing Torres, Sisip Salazar Hernandez, and Gat Maitan. Okay, these are law firms. Mga partnerships po ang mga yan. Pero ang main na purpose nila is to exercise their profession. Tandaan po natin yan. With that, let's distinguish ordinary business partnership and general professional partnership. This is the only difference nila, itong dalawa. The first one, yung main purpose. Dun sa first paragraph, if babalikan natin dito, ang intention is to divide their profits. Okay? The intention is to divide their profits among themselves. So GPP naman is, paulit-ulit, exercise of profession. So yun yung main purpose. Yun yung difference. Although sa GPP, may kita pa rin sila, profits are merely incidental lang sa purpose nila. Siyempre, kailangan din nilang gumastos. So, kailangan din nilang paghatian yung mga profits. Okay? So, let's proceed to the second difference. Under ordinary business partnership, yung mga binanggit ko kanina, yung mga McDonald's, Warner Brothers, they shall be subject to income tax like corporations. So, ibig sabihin, yung partnership mismo, matataksan. Okay? Yung partnership mismo, matataksan. In simple words. Sa GPP naman, the partnership itself shall not be subject to income tax. In simple words, yung partnership hindi matataksan kung ang partnership nila is GPP or exercise of profession. Basta nakita mo na lawyers yan or na CPAs yan, hindi subject sa tax yung partnership. However, yung partners, yung mga CPAs mismo, yung mga lawyers, they are subject to income tax. So lahat ng kita nila sa partnership na yun, na madidistribute through dividends, i-declare pa rin nila. In other words, matataksan pa rin. Pero hindi kasi matataksan yung partnership itself. You get the point? Okay, silence means yes. So let's proceed. So yun balikan natin, distinguish OBP from GPP, dalawa lang yan, the main purpose and then taxation. Main purpose sa OBP, the main purpose is to divide the profits among themselves. Sa GPP, to exercise their profession. Sa OBP, sa taxation, hindi siya subject siya sa tax. Ibig sabihin, yung partnership matataksan. Tapos sa GPP, hindi siya subject sa tax. Characteristics of partnership. Number 1, consensual. Babalik tayo dun sa una na sinabi natin kanina, sabi din ng batas, by the contract of partnership. Contract. Elements of a contract, may consent. Characteristic, consensual. No? Sana mabuo nyo yan. Mapagduktong-duktong nyo yan. Consensual siya. Bakit? Kasi nga, as I have explained earlier, a contract is a meeting of minds of the contracting parties. A partnership, aside from being a type of business organization, is also a contract. It is perfected by mere consent. This is because of the principle of the Teka lang, wait lang. May nag-join. Delectus personae, literally choice of the person, or delectus personarum, wherein each partner is entitled to exercise their choice and preference of partners. Ibig sabihin, let's say for example, si A tsaka si B gustong mag-enter into a partnership. Ngayon si C, gusto niyang sumali pero ayaw ni A at ni B. Hindi mo pwedeng pilitin si A tsaka si B na isali si C. Kasi nga, the principle of delectus personae, it's a choice of the person. Kung pumayag si A tsaka si B na mag-partnership kay C, okay, why not? Diba? Yun ang tandaan nyo, consensual. At the moment na pumayag sila, na nag-agree sila na, okay, sige, pasok tayo sa partnership. Gawa tayo ng partnership. There's already an existing partnership. Okay? Now, example. A and B entered into an agreement to form a partnership. Because of A's refusal to comply with the agreement, B sued A for the execution of a partnership contract. Ngayon, ito yung scenario. Diba? Sabi A and B, nagkasundo si A tsaka si B na bumuo ng partnership. So, kung ipipicture nyo, nag-usap pa lang sila, oral. Wala pang written contract. Hindi pa sila nag-execute ng articles of partnership. Wala pang kasulatan. Ngayon, dumating yung panahon na gusto ng bumuo ng contract ni B, ayaw ni A. Sabi dito, because of A's refusal to comply with the agreement, kinasuhan siya ni B. Sabi ni B, pumayag ka noon sa akin na na magagawa tayo ng contract. Ngayon, mag-execute na tayo, ilagay na natin sa kasulatan. Ang tanong, pwede ba yun? Pwede bang pilitin ni B si A na isulat nila yung napagkasunduan nila kung ayaw ni A? Yun yung question. May A be compelled against his will to carry out the agreement or execute the partnership contract? Lagi niyong babalikan, delectus personae. Okay, wag niyo kakalimutan, delectus personae. Kahit hindi niyo masabi ang delectus personae, sabihin niyo lang na contracts are consensual. Pwede na yun. Kasi nga, kung ayaw ni A na mag-enter na into a contract of partnership, hindi na mapilit ni B. So, ang sagot dito is no. B cannot compel A to enter or to execute the partnership contract. Notwithstanding na meron silang napag-usapan before na mag-enter sila into a contract. Bakit? Kasi yung pagpirma o yung pag-consent is an obligation to do. Balik ulit tayo sa obligon nyo kung anong year nyo siya natutunan. Di ba ang obligation, merong obligation to give, not to give, to do. Di ba? May mga ganun. Kapag to give, not to give, pwede mong pilitin na ibigay kasi ibibigay lang naman. Kung ayaw ibigay, bibigyan ng pera para bumili ng ganung bagay. To give or not to give, pwede yun. Pero pag ang sabi obligation is an obligation to do, pipirma siya dun sa contract or makikipag-enter siya into an agreement with you, Hindi pwede. Kasi labag na yun sa karapatan niya. Meron tayong tinatawag na rights. Right against involuntary servitude. Tsaka right to consent. Kung ayaw niya, ayaw niya. Di ba? Pwede mo na lang siyang kasuhan kasi pinaasa ka niya noon na sabi niya mag-form kayo ng partnership. Ngayon, pipirmahan na kayo, ayaw niya na. Pwede mo siyang kasuhan, damages. Pero hindi mo siya pwedeng pilitin. Clear? I think that's clear. Number 2.
Opo.
The second, yes, thank you. Second characteristic, principal. Partnerships are principal contracts. Ibig sabihin, they are the main contracts or they can stand by themselves. They don't depend on other contracts. Principal. Ibig sabihin, let's say for example, partnership A, B, C entered into a loan agreement with a financing company. Okay? The loan agreement is not a principal contract. Okay? It's the partnership. Yung paggawa ng partnership. So, yun yung principal contract. The third one is bilateral contracts. Are those wherein all parties are required to give or do something. Ngayon, lahat naman ng ito ng sinasabi natin, makukuha mo na dun sa unang paragraph pa lang. Balikan natin. Article 1767 pa lang. Diba? 2 or more persons bind themselves to contribute money, property, or industry to a common fund. Nandun na yun, bilateral. Diba? And in turn, they will receive share from the profits. And their rights and obligations are reciprocal to each other. So, each partner shall contribute something, either money, kung mayaman ka, property, di ba? Or kung wala ka namang pera, gusto mong sumali, industry, ako na lang yung general manager, ako na lang mag-manage ng partnership, why not? Pwede. Okay? Ganun. So, lahat sila may bibigay. Lahat sila magbibigay, lahat sila may share sa profits, lahat sila may rights, may obligations under the partnership. Example, A bought an old house. So, si A lang bumili. Sabi niya kay B, he would give half the profit of the sale if B would repair the house. Ngayon, nakalipas ang ilang buwan, A hired C to repair the house and was able to sell at profit. Question. Is there a partnership between A and B? So, ang sagot dyan, no. There is no partnership formed between A and B. Kasi, balikan mo yung principle ng bilateral contracts. A was supposed to buy the house. Wait lang. A was supposed to buy the house. Yun yung contribution niya. Si B naman was supposed to repair the house. Pero hindi nangyari. Si A pa rin ang nag-hire kay C na mag-repair nung house. So there was no bilateral agreement. There was no agreement between A and B. Hindi nabuo yung agreement nila. So si A lang, in turn, parang si A lang pang gumastos sa lahat. So walang partnership kay A tsaka kay B. So take note of these things, Malay nyo, yan na mismo ang quiz nyo. Ang assessments nyo. Okay, number 4, nominate. Partnership is nominate or nominate contracts. Ibig sabihin, it has a name. The law gives a name to a partnership contract. Ang tawag dun, partnership. Kaya siya nominate. Kung in-nominate naman, ibig sabihin walang pangalan na binigay ang batas sa kanya. Ibig sabihin, kunwari, napaka-unusual ng contract nyo, wala kayong mahanap sa batas na contract na ganun. In-nominate yun, walang pangalan. Ito kasi, mayroong designation na binigay yung batas. Ang tawag, partnership. Okay, number 5, preparatory. Connect mo to dun sa principal. Preparatory siya kasi kung wala itong partnership contracts, hindi kayo makapag-contract sa sa customers nyo, sa financiers nyo, sa suppliers. Wala. Ibig sabihin, kailangan meron munang contract of partnership bago kayo makapag-enter into other contract. Kaya siya tinawag na preparatory contract. Parang nagprepare ka parang nagprepare ka para makapag-enter kayo into other contracts. Relate mo siya dun sa principal. Okay? Number 6, onerous. The contract of partnership is onerous because the parties have to give up something. Yun ang ibig sabihin ng onerous. Kung nalilito kayo sa onerous, pwede nyo siyang tawagin na burdensome. Ibig sabihin, burden siya. Kasi, bakit burden? Kasi magbibigay ka eh. You have to give up something. Okay? Either money, property, or industry. Clear? So yun. Recap. Consensual, of course, sa contract. Principal, bilateral, everybody has to contribute. Nominate, it has a name in the laws. Preparatory, it is a contract in preparation for engaging into other contracts. Onerous, burdensome. Kasi magbibigay kayo ng money, property, or industry. Now, to Article 1768, the partnership has a juridical personality separate and distinct from that of each of the partners, even in case of failure to comply with the requirements of Article 1772, first paragraph. So, in short, in simple terms, the partnership is separate from the partners. So, nakikita nyo yung presentation, nakita nyo may mga tao dyan, hindi na natin papangalanan. Person 1, person 2, person 3, and then sa gilid, meron yung Del Monte na logo. Okay? Dito sa dalawang pictures na ito, may 4 na tao. Sino? Si person 1, si person 2, si person 3, at saka si Del Monte, which is their partnership. So yung partnership is tao din siya. Babalik tayo dun sa sinabi ko kanina, there are 2 kinds of person. You have natural person, you have juridical person. Ayun si partnership, juridical person. So pag sinabi natin, a partnership is a juridical person, can you still hear me?
Yes, sir.
So kapag
Yes, sir.
Okay. Thank you.
Yes, sir.
Okay. Kapag sinabi natin the partnership is a juridical person, ibig sabihin, Article 1768, it has a separate and distinct personality from that of the partners. Iba siya kay partner 1, iba siya kay partner 2, iba siya kay partner 3. Siya, mayroon siyang sariling katauhan. Ganon yun. Ibig sabihin, si partnership Del Monte, pwede siyang bumili ng properties niya, pwede siyang magbenta ng properties niya, pwede siyang mag-own, pwede siyang isu and bisud, pwede siyang kasuhan at makasuhan, pwede siyang magkaso. Okay, para din siyang tao. Pero hindi siya natural person, juridical lang siya. Okay? Pag nabasa niyo yan, because it has a separate and distinct personality aside from that of the partners. So, dyan sa pictures na yan, 4 na tao yan. Okay? Article 1772. Every contract of partnership having a capital of 3,000 pesos or more in property or money shall appear in a public instrument which must be recorded in the office of the SEC. Okay? Ito naman, formality. Formality lang ito. Hindi, let's say for example, A, B, C entered into a contract of partnership. Ang total capital nila na naipon is 15,000. Let's say for example, 5,000 each. A, B, C, 5,000 each. Okay? Ang sabi sa batas, kailangan ang contract of partnership nasa public instrument. Anong ibig sabihin ng public instrument? In simplest terms, ayoko nang pakomplikaduhin sa inyo. Kapag public instrument yan yung mga ninonotaryo Nakakita na kayo ng notary public, ganun, sa palengke, kahit saan kayo pumunta. Yun yung public instrument. Kapag tinatakan na yan ng notaryo, o kapag pinanotaryo nyo na yan, ang isang dokumento o isang papel, magiging public instrument. In short terms yun ha. So dapat kapag ang capital nila is more than 3,000 pesos or 3,000 and more or more, ibig sabihin dapat in a public instrument, in other words, mapanotaryo. Tapos ipapasa yan sa SEC. Pero the partnership still exists kahit wala yan. Let's say for example, ABC, 5,000 each yung contribution. Hindi sila nagpa-register sa SEC, hindi sila gumawa ng public instrument. Is there a partnership? Yes, there is still a partnership. Hindi lang nasunod yung formality. Ang kailangan lang gawin dyan, mag-execute sila ng contract, ipapanotaryo, bibigay sa SEC. Ganun lang. Tignan mo yung sabi sa baba, sa second paragraph niya. Failure to comply with the requirements of the preceding paragraph shall not affect the liability of the partnership and the members thereof to third persons. So kahit hindi sila nakapagpagawa ng public instrument, kahit hindi sila nakapagpanotaryo, kapag nakipag-enter sila into a contract with third persons, ang third persons, from here on out, kapag sinabi natin third persons, yan yung mga buyer, yung seller, mga financier, mga supplier nyo ng partnership. Hindi sila makapag-enter into a contract. Pero ito, kahit wala daw silang in-execute na public instrument, liable pa rin sila sa kanilang supplier in case meron silang kontrata na pinirmahan. Yun lang yung in the shortest term na explanation nun. Kahit hindi nasunod dito, liable pa rin sila sa third persons. Okay, clear? Ngayon, sa madaming scenario at circumstances, hindi natin kaagad ma-determine if meron bang partnership or wala. Let's say for example, number 1 of Article 1769. Persons who are not partners as to each others. Ganito magbasa ng ng provision. Kung may nakita kang except as provided, pwede mo siyang skip. Pwede mo siyang skip hanggang dun sa kama. Tapos, kasi yun yung exception mo eh. And then, dun ka mag-start sa next na statement. Persons who are not partners as to each other are not partners as to third persons. Yan yung general rule mo. Okay? In short, hindi tayo, si A tsaka si B, hindi mag-partners. Okay? So, hindi sila mag-partners, ibig sabihin, hindi sila mag-partners as to third persons, as to buyers, as to sellers, as to suppliers. Yun yung common sense nun. Hindi nga sila mag-partners, hindi sila partners sa mata ng ibang tao. Pero may exception siya, except partnership by estoppel. O ganito, si B, sabi niya kay A, meron akong customer, let's say for example, nagbebenta ng lupa. Meron akong customer. Gusto mo sabihin ko sa kanya, mag-partners tayo. Tapos yung profit, hati tayo. Okay? Yun ang sabi ni B kay A. Si A naman, walang imik. Hindi nag-object, hindi nagsalita. Ngayon, nag-execute sila ng deed of sale, nabenta yung lupa, pero nalaman nung pinagbentahan ni B na hindi pala sa kanya yung lupa, liable ngayon si A tsaka si B. Bakit? Kasi hindi niya dinenay eh. Nung may opportunity na sinabi niya na partners tayo, hindi naman nag-object si A. So, sa mata ng buyer ng lupa, mag-partners silang dalawa. Walang kasalanan yung buyer doon kasi nagtiwala siya. Mag-partner kami ni A tsaka ni B, sa amin yung lupa. Liable ngayon si A tsaka si B. Yun yung partnership by estoppel. Although hindi sila mag-partner, dahil meron silang liability, magiging mag-partner sila sa mata ng batas at sa mata ng buyer. Naintindihan ba yun? Baka mabilis. Okay naman. Yun ha.
Okay
Hindi,
lang po.
okay lang, sige. Hindi sila mag-partner, pero sa mata ng mga third persons, mag-partner sila. Yun yung exception. Okay? General rule, hindi sila mag-partner sa mata ng tao. Pero kung nagpakita sila na partner kami, ganun, liable sila as partners. Ganun yun. So, number 2, co-ownership or co-possession does not of itself establish a partnership. Whether such co-owners or co-possessors do or do not share any profits made by the use of the property. Para makarelate kayo, let's say for example, may kapatid ka, o si A tsaka si B magkapatid. Ngayon, yung tatay nila, let's say for example, tatay na lang nilang buhay. Yung tatay nila, kapag namatay, lahat ng ari-arian ng tatay nila mapupunta sa kanilang dalawa, kay A tsaka B, dun sa magkapatid. Magiging co-owners sila. Yun yung co-ownership or co-possession na sinasabi natin. Hindi ibig sabihin na, ang sabi dito sa number 2, hindi ibig sabihin na co-owners sila, partners na sila. Okay? Iba ang co-ownership sa partnership. 2 or more persons may become co-owners without a contract, but they cannot be partners in the absence of a contract. So, dapat meron pa ring contract of partnership. Kapag sinabi natin contract, whether oral or written, kahit nag-usap lang sila, okay lang. Basta may contract, oral or written. Okay? So, hindi ibig sabihin na tayong dalawang may-ari ng isang bagay, mag-partners na tayo. Hindi. Example, A and B inherited from their father. Yun yung example ko kanina. Ngayon, itong si A at si B nag-inherit ng apartment na pinapaupa nila sa mga pinapaupa nila. Are they partners? The answer is no. They are co-owners. Okay? Bakit hindi sila partners? Kasi nga, there is no proof of partnership. Walang agreement na maghahati sila dun sa profits, dun sa lease. No? At saka, hindi mo naman mapapakita ka agad na may contribution silang dalawa since from the very beginning, co-owners sila. Pero paano kung binenta nila yung property at pinaghatian yung income? Yun yung tinatawag nating transformation from co-ownership to partnership. Excuse me. Kahit wala silang written contract, if meron silang oral contract, ibig sabihin pinag-usapan lang na ibenta na natin yung apartment, tapos paghatian natin yung proceeds ng sale, pwede yun. Pwede yun na maging partnership. Pero kung yung in-inherit lang nila, walang partnership dun. Magkaka-partnership lang pag may agreement sila na maghahati. So kung babalikan nyo lahat, babalik tayo sa 1767, dun sa pinakauna. Na yung intention nila is to divide their profits. Okay? Another example, si A and B ulit. They put up money to buy lottery tickets for the sole purpose of dividing equally the prize money which they may win. In the event na manalo sila, are they partners? Yan. Babasahin mo mabuti, A and B put up money. So, si A at si B may contribution. So, okay na. 2 or more persons may contribution. Nag-agree sila, may consent, may contract to buy lottery tickets. Anong purpose? For the sole purpose of dividing equally the prize money which they may win. So, merong agreement to divide profits. Are they partners? Yes. Pwede mo lang sabihin yung 1767. Di ba? Because A and B agreed to put up money to buy lottery tickets and then divide the profits after they win. That is partnership. Kung babalikan mo yung 1767 kanina, Yun na yun yung partnership. So yes, they are partners. Okay? So the third scenario, the sharing of gross returns does not of itself establish a partnership, whether or not the persons sharing them have a joint or common right or interest in any property from which the returns are derived. In short, ganito yung number 3, hindi ibig sabihin na nag-share sila sa returns, mag-partners na sila. Okay? The sharing of gross returns does not itself establish a partnership. Hindi automatic partners na sila. For example, boundary system. Let's say for example, si A, merong tricycle. Okay? Si A may tricycle. Ngayon, may kakilala siya, si B. Si B ngayon, isang driver, tricycle driver. Ngayon, nag-agree sila na si B, drive niya yung tricycle, magpipick up ng pasahero, yung gas, sagot ni B, yung pag-repair kay B na rin, wala nang gastos si A dyan. Tapos lahat ng makukuha nila dun sa income na sa pagpapasada, paghahatian nilang dalawa. May partnership ba dun? Wala. Wala pong partnership dun. Hindi ibig sabihin na nag-share sila sa gross returns, meron ng partnership. There must be an agreement that they will share the profits. Ang boundary system kasi, usually si A lang or yung may-ari lang ng tricycle ang nag-i-impose nun. Okay? Sige, let's say for example, 60-40 tayo sa sa kita sa tricycle. 'Di ba? Pero lahat naman ng gastos kay B lang. So hindi siya partnership. Kasi kung partnership 'yun, lahat dapat ng gastos sa gasolina, in case masira, lahat dapat 'yun hati silang dalawa. Hindi si B lang di ba? Gets niyo? Si B lang. Si B lang yung si driver lang lahat sa gas, sa pagpapaayos. Sa kita lang sila maghahati. Hindi siya partnership. Babalikan mo yan dun sa characteristic ng partnership na diniscuss natin kanina, which is bilateral. Hindi siya bilateral. Okay? Number 4, the receipt by a person of a share of the profits of a business is prima facie evidence that he is a partner in the business. But no such inference shall be drawn if such profits were received in payment of debt, of wages, of annuity, of interest on a loan, or on a consideration for the sale of goods. Ang haba. In short, kung may na-receive yung isang tao sa share ng isang business, hindi automatic ibig sabihin nung partner siya or may partnership sila or kasali siya sa partnership. Hindi. Hindi porket may na-receive siyang payment, partner na sila. Yung prima facie evidence na tinatawag natin, ibig sabihin, wala ka nang kailangan i-prove. Yun na yun yung evidence. Hindi. Hindi porket may na-receive siyang share. Kasi baka naman, ito ay bayad sa debt, utang. Baka naman ito ay sahod niya, kaya siya nakaka-receive ng share sa partnership. Kasi sahod niya pala yun. Baka naman pension niya yun, or annuity. Or baka naman interest yun sa pinuutang niya sa partnership. Or baka dahil sa nagbenta siya ng goodwill or property dun sa partnership, kaya siya nakakuha ng share. Okay? So hindi ibig sabihin na may nakuha kang share sa isang business o sa isang partnership, partner ka na, hindi. Pwedeng bayad yan sa utang, pwedeng sahod mo yan, pwedeng pension yan, pwedeng interest yan sa utang, or pwedeng yung bayad mismo sa, kunwari, nabenta mo yun. Ganun. Hindi siya automatic na mayroong partnership. Clear? Clear.
Opo.
Yes. Okay. Itong Article 1770, babalik ka rin sa 1667. By the contract of partnership na sinasabi natin, kapag sinabi mo kasing contract, kapag bumalik ka sa oblikon, ang object ng contract dapat lawful. Okay, dapat lawful. Sabi dito, a partnership must have a lawful object or purpose. Kaya nga nang in-explain din natin kanina, kapag ang object ng partnership is pagbebenta ng drugs or pagkikidnap ng bata, pagbebenta ng mga internal organs nila, hindi siya lawful partnership, hindi siya partnership. Okay? And must be established for the common benefit or interest of the partners. Ibig sabihin, kung magpa-partnership kayo, kailangan lahat may share sa profits. Well, ABC partners, CC walang share sa profits, that's not partnership. Di ba? Okay. Second paragraph ng 1770. When an unlawful partnership is dissolved by a judicial decree, the profits shall be confiscated in favor of the state. Okay? Di bang sabi natin, a partnership that doesn't have a lawful object is void. Void yan. Pero ang void na contract, kailangan i-declare ng court na void. Hindi mo siya pwedeng sabihin na void yan. Na ikaw lang na tao or kahit ako lang na abogado magsabi void yan. Hindi. Kailangan may judicial decree. Mayroong judgment ng court na na-dissolve siya because the partnership is unlawful. Okay? Kapag at the time na na-declare siya na unlawful, yung profits, whatever profits na makuha sa pagbenta ng drugs, confiscated yan in favor of the state. Ibig sabihin, mapupunta sa gobyerno yan. Oh. Okay? Kapag nag-form siya ng unlawful partnership, mapunta sa gobyerno yan kasi corrupt. Hindi. Kasi unlawful siya. Okay? Alangan naman na dissolve yung partnership kasi nagbebenta kayo ng drugs. Paghatian niyo yung kita niyo, edi parang kinonsent niyo na rin na mayroong unlawful partnership, di ba? So kaya lahat ng kita sa state. Okay? Without prejudice to the provisions of the penal code governing the confiscation of the instruments and effects of a crime. Medyo deep na yan. Hindi natin yan i-focus. Kasi yung sa penal code naman, sasabihin niya rin yan sa state. Ganun din yan. Sa gobyerno din yan mapupunta. Okay? So, kaya lahat ng mga sinisis ng mga profits sa government. Okay yun ha. Partnership must be lawful for the common benefit. Kung sakaling unlawful yan, kailangan may judicial decree. Kailangan may declaration na galing sa court na void yan, unlawful. Lahat ng profits mapupunta sa government, sa state. Wake up yun ha. Okay. Next topic, forms of a partnership contract. Anong oras na? 7. Okay. Generally, a partnership contract can be in any form. Kaya nga lang sabi natin kanina, a contract can be oral or written. Kaya ang partnership contract can also be oral or written. Except for formality's sake, number 1, if real property is contributed. Sir, ano yung real property? Ang real property, according to Article 1774, is any immovable property or interest therein. Kapag immovable property, from the word itself, immovable, yun yung mga lupa. Cannot be moved. Diba? Bahay cannot be moved. Medyo simple, diba? Ganun lang yun. Real property is equals to immovable property. Lahat ng hindi mo ma-move. Yan. Immovable property yan or real property yan. Big sabihin, let's say for example, ABC entered into a partnership. A contributed his land. Okay? So kapag merong real property na na-contributed, may lupa, dapat daw ang partnership contract is naka-public instrument. Public instrument, yung sabi ko kanina, papanotaryo mo sa notaryo publiko, sa notary public. Okay? Number 1 yun na, public instrument. Number 2, merong inventory. Okay? Tandaan nyo ha, public instrument, inventory, and signed by the parties that is attached to the public instrument. Otherwise, the contract is void. Okay? Ito yung instance na magdedepende yung legality ng partnership dun sa contract. So kung basta merong building, merong lupa na involved, na kinontribute sa lupa, take note ha, take note. Automatic, kailangan, it must be in a public instrument, it must be inventory, may inventory, and signed by the parties. PIS, tandaan niyo yan. Tapos, kapag kinontribute mo yung immovable property na yan, yung lupa na yan, yung title must be in the partnership name. Pwedeng ibenta yan, pero in the partnership name. Okay? Bakit in the partnership name, sir? Babalikan mo yung kanina na sabi natin na ang partnership is a juridical person. So, para siyang tao din. Kung i-contribute mo siya sa partnership, ipapangalan mo na siya sa partnership. So, hindi na si A ang may-ari ng lupa kung sakaling kinontribute niya yun. Magiging pangalan na ng partnership. Okay? Take note, kung may real property, mayroong lupa, building na kinontribute, PIS, public instrument, inventory, and signed by the parties. Kung capital niya naman exceeds is 3,000 or more, yung explanation natin kanina, okay? It must be in a public instrument and must be registered with the SEC. In-explain ko na ito kanina, di ba? Pero hindi siya void. Unlike yung kanina, yung may real property, ang sabi dyan, otherwise it is void. Okay? Dito sa kapag 3,000 or more, hindi siya void. Sink in. Okay? If the partnership is a limited partnership, a certificate signed under oath by the partners and recorded with the SEC. So, merong certificate under oath and recorded with the SEC. So, general rule, recap, general rule, partnership kahit anong form. Oral, ibig sabihin usap-usap lang, pero nag-agree kayo sa usapan. Or written, meron kayong pinirmahan na kasulatan, pwede. Okay, that's the general rule. Exception, kung may lupa, building, kailangan PIS, public instrument, inventory, signed. Kung 3,000 or more, kailangan public instrument, recorded with the SEC. Kung limited partnership, certificate, oath, SEC. Okay? Sige. Next, we go to another kind of partnership. Secret partnership. Ito yung mga uso to ngayon no? Yung hindi fineflex sa social media. Pag hindi ka fineflex sa social media, secret partnership yan. Okay? Ano ibig sabihin nun, sir? Associations and societies whose articles are kept secret among the members and wherein any one of the members may contract in his own name with third persons shall have no juridical personality and shall be governed by the provisions relating to co-ownership. Ibig sabihin, nag-enter kayo into a partnership pero hindi mo alam kung ano yung purpose ng partnership mo, ano yung binibenta. Kasi yung articles of partnership is kept secret among the members. Kumbaga, nag-invest ka ng, kunwari ABC, si C nag-invest lang ng 10,000, pero hindi niya alam kung ano yung business ng partnership. Hindi niya alam kung paano yung performance, wala siyang idea. Oh, di ba? So, walang personality ang partnership na gano'n. Kasi yung mismong articles of partnership na kung saan doon mo makikita kung anong business, kung saan yung office, lahat tungkol sa partnership is kept secret sa'yo, hindi siya partnership. Di ba? Ganun. Or, kung kahit sino sa kanilang members, pwede silang mag-act in their own behalf. Ibig sabihin, clear example, partnership engaged sa pagbenta ng lupa. A, B, C sabihin mo. Ngayon si A, pwede siyang magbenta ng lupa sa kanya mismo. Hindi pwede yun sa partnership eh. Kapag nag-partner si A, tsaka si B, tsaka si C, ibig sabihin, lahat ng lupa na mabenta nila dapat kay A, B, C partnership. Hindi sa kanila, hindi sa isa't isa. Gets nyo? Yan yung tinatawag nating secret partnership. Bakit? Bakit sir na hindi pwede na kunwari may mabenta ako, di mas maganda kung ako lang ang magbenta, sa akin lahat ng komisyon, ng profit. Hindi. Kasi 1803, a partner is considered as a co-agent of his partners. Kahit walang makita sa'yo, kung may mabenta ka na lupa, dapat i-report mo yan sa partnership. Kasi partner ka na eh. You're acting through mutual trust and confidence. Yun yung hawak mo. Okay? Parang sa ano din yan, sa relasyon. There must be trust and confidence. Mutual trust and confidence. Kung wala yan, wala din. Ano bang silbi? Nagsayang lang kayo ng oras, di ba? Okay, so that's it. Secret partnership. Okay, let's discuss further the kinds of partnership. Na-discuss natin yung number 1 kanina, as to purpose. Ordinary, business partnership, and general. Di ba? If you can recall, kanina, ordinary, nag-share lang sila ng profits. General professional partnership, nag-form sila ng partnership mainly to exercise their profession. Di ba? Taxation naman, yung OBP, matataksan, yung GPP, hindi matataksan. Okay? Number 2 na tayo, as to object or extent of its subject matter. The first one under as to object or extent is universal partnership. Dalawa yan eh, universal and particular. Una muna, universal partnership, which may refer to either universal partnership of all present property or universal partnership of profits. I-discuss natin yan. Universal Partnership of All Present Property or UPPP. Ibig sabihin, all the property which actually belongs to all the partners shall be contributed to a common fund. Ibig sabihin, lahat ng ari-arian nila ipapasok nila sa partnership at ang intention nila is paghahatian nila lahat ng ari-arian nila, pati yung profits. Yan yung UPPP. Okay? All the property of all the partners are contributed to the partnership with the intention of sharing the profits and the property. Yung buong property, paghahatian nila lahat yun. Yun yung UPPP. Okay? The property which belong to each of the partners at the time of the constitution of the partnership becomes the common property of all the partners. Kasi nga, lahat ng property kinontribute. Therefore, lahat ng property na yun mapupunta sa partnership at yung partnership na yun, common property ng partners. Ibig sabihin, paghahatian nila yun later on, as well as the profits. I hope you can follow. Lahat papasok, lahat paghahatian. Hindi yung papasok, kanya-kanya paglabas. Hindi. Lahat papasok, paghahatian yung pinasok. Okay? A stipulation for the common enjoyment of any other profits may also be made, of course. But the property which the partners may acquire subsequently by inheritance, legacy, or donation cannot be included in such stipulation except the fruits thereof. Let's say, for example, si A tsaka si B, para mas simple. Si A tsaka si B, nagkasundo sila lahat ng properties nila, if i-contribute nila into a partnership. Okay? So, lahat ng properties na yun is partnership property na yun. Ibig sabihin, common property na yun ng partners. Ngayon, say for example, si A, biglang namatay yung parents, na-inherit niya lahat ng property nila. Or, si A nakatanggap ng donation galing sa papa niya o sa mama niya. Yung natanggap niya yun na inheritance or donation, hindi yun kasali dun sa common property. Gets nyo? So yung mga kinontribute nila before ng donation or before ng inheritance is sa property yun. Kung ano man ang ma-inherit ni A or ni B, or ma-receive nila sa donation, hindi yun kasali sa partnership property. Except lang yung fruits lang nun. Okay? Or except if ang pag-usapan nila, let's say sa partnership contract, ang sabi nila dun, kapag mayroong nag-donate sa akin o pag may na-inherit ako, kasama yun sa partnership property. Pwede yun. Pero ang general rule, kapag may na-inherit or na-donate, hindi siya kasama. Okay? Hindi siya kasama. General rule. Pwede nilang pag-usapan na kasama. Kaya ang sabi dyan, or donation cannot be included except the fruits thereof. Okay? Basta may stipulation, ang general rule kasi dyan, basta may stipulation, yun ang masunod. Kung walang stipulation or walang agreement, batas ang masunod. Ganun sa contracts, babalikan mo, obligon mo. Kapag may stipulation, stipulation ang i-follow basta hindi contravening sa law. Kung walang stipulation, walang kasunduan, yung law ang i-follow mo. Okay? Yun yung UPPP, Universal Partnership of all present property contributed into the partnership. Lahat ng property na yun maging property ng mga partners, hindi na kanya-kanya, lahat na yun sa kanila. Okay? Ang okay, wait. Okay. Yun yung UPPP. Ano naman yung UPP? A universal partnership of profits comprises all the partners may acquire by their industry or work during the existence of the partnership. Ibig sabihin, hindi nila kinontribute yung property nila. Okay? Hindi lahat. Ang kinontribute nila is yung industry or yung work nila. Ang paghahatian lang nila dyan, from the name itself, profits. Sir, paano kung may ginamit silang lupa, anong ano? Yun lang yung usufruct. Kaya ang sabi dyan, movable or immovable property which each of the partners may possess at the time of the celebration of the contract shall continue to pertain exclusively to each, only the usufruct passing to the partnership. Ibig sabihin, para hindi kayo mahirapan, pag sinabi natin usufruct, use, okay? Only the use. Ibig sabihin, hindi niya dinonate, hindi niya kinontribute yung property mismo, ang kinontribute niya yung paggamit ng property lang. Okay, let's say for example, may building ako, hindi ko i-contribute yung building, pero pwede ko kayong i-allow na gamitin niyo isang floor ng building, okay lang yun. UPP yun. Hindi mo kinontribute yung property. Okay? Universal partnership of all present property, lahat ng present na property ko contribute. Profits lang ang paghahatian. Ibig sabihin, industry work lang ang kinontribute. Presumption, sir, paano kung walang nakalagay sa contract nila na universal partnership of all present property or profits? Ano ang presumption? Ibig sabihin, kung walang nakalagay, ang presumption, isa siyang universal partnership of profits. UPP siya. Ito siya. Bakit? Kasi less onerous. Balikan mo kanina, onerous, burdensome. Less burdensome siya sa mga partners. Bakit, sir, na less burdensome? Kasi kung universal partnership of all present property siya, lahat ng ari-arian ng partners magiging property ng partnership. Di kawawa naman yung mga partners. Silent naman yung... Ito pag silent lang yung contract, ibig sabihin walang nakalagay kung universal partnership of all present property or universal partnership of profit siya. Walang naka-specify. Kaya ang assumption, universal partnership of profit siya. Kasi less onerous, less burdensome sa mga partners. Bakit? Kasi kung UPP, ma-retain nila yung ownership nila. Yung use lang yung pumunta sa partnership. Kaya siya less onerous. May limitation ba sa universal partnership? Yes, there are. Okay? Those who are prohibited from giving each other any donation or advantage cannot enter into universal partnership. Under the family code, under Article 87 of the family code, ang mag-asawa, husband and wife, legally na kinasal, hindi ho pwedeng mag-donate sa isa't isa. Okay? Sir, paano yung hindi siya pwedeng mag-gift. Sir, paano yung mga binigyan ko yung asawa ko ng cellphone, binigyan ko yung asawa ko ng kotse. Okay lang yun, moderate gifts, okay lang yun. Pero yung mga lupa, yung mga building, ganun, they are prohibited to make a donation. And at the same time, they are prohibited to enter into universal partnership. Basta mag-asawa, bawal sa universal partnership. Sir, paano kung hindi sila kasal, mag-live-in sila, prohibited din ba sila mag-enter into universal partnership? Yes. Kasama kasi yan sa Article 87 of the Family Code. Ang sabi kasi dun, including those persons who are living together without the benefit of marriage. O, yan. So, pag mag-live-in kayo, hindi kayo pwede mag-join into universal partnership. Example, ABC entered into a particular partnership. Later, B and C got married. And A also sold his share to both B and C. Was the partnership dissolved by the marriage of B and C and the subsequent sale of C's share to both of them? The answer is no. First and foremost, yung example ko dito is a particular partnership. Hindi siya universal partnership. Second, kahit pa nagpakasal si B tsaka si C, hindi ibig sabihin nun madi-dissolve na yung partnership. Kasi yung share nila is separate. Kasi nga particular partnership siya. Hindi siya universal partnership. Okay, so the answer is no, the partnership is not dissolved by the marriage of B and C and the sale of C's share to both of them. Okay? Okay. And there are other persons who are prohibited. So yung una, yung prohibited na sumali sa universal partnership, mag-asawa, kasal, or nagli-live-in, hindi kasal, prohibited to join universal partnership, or those who are guilty of adultery or concubinage at the time of donation. Ibig sabihin, kasal ka, may asawa ka, whether babae ka man o lalaki, tapos nakipag-siping ka sa ibang lalaki o sa ibang babae, hindi kayo pwede mag-join to universal partnership. Okay? Kasi bawal yun. Pangalawa, those made between persons found guilty of the same criminal offense. Let's say for example, si A at si B, nakanakaw sila ng 10 million pesos. Nag-enter sila into a partnership. Yung nanakaw nila, yun yung invest nila, hindi pwede yun. Kasi para mo na rin pinalusot yung crime dun, di ba? Those made between persons found guilty of the same criminal offense. Hindi pwede yun. The third one, those made to a public officer or his wife, descendants, and ascendants. O yung mga nagbibigay ng lagay, hindi pwede yun. Made to a public officer. Hindi kayo pwede mag-enter into universal partnership. Ibig sabihin, the law does not condone criminal offenses. Diba? Adultery, concubinage, guilty of the same crime, public officer or his wife na binigyan mo ng pera or ng property, which is rampant, hindi pwede yun. Okay? Then the next kind of partnership based on its object or extent is particular partnership. Ibig sabihin, from the word itself, particular thing lang or determinate thing lang, particular use lang, particular fruits lang, particular profession lang or undertaking lang, particular partnership. Balikan mo yung kanina, universal partnership of all present. Ibig sabihin, kung ako, lahat ng ari-arian ko, lahat yun mapupunta sa partnership. Ganun. Dito kasi particular lang. Sige, bigay ko na yung lupa ko, bigay ko na yung sasakyan ko, ganun. Particular partnership yun. Okay? So, yun yung difference niya sa universal. As to liability, malapit na to. Matatapos na, sakto lang. As to liability, general partnership and limited partnership. General partnership, lahat general partners. Lahat general partners. Limited partnership, hindi lahat limited. May isang general partners. Okay? At may isang limited partners. Bakit kailangan ng general partners? Sabi mo kanina sir, sa general, lahat general partners. Sa limited, hindi lahat limited. Kailangan may isang general partner. Bakit kailangan may isang general partner sa isang limited partnership? Kasi, kung mabasahin mo yung definition dyan, a general partner is liable even beyond his contributions to the partnership. Let's say, for example, particular partnership, yung kanina, example natin. Ako, general partner. Ngayon, nalugi yung partnership, or merong utang yung partnership. Ngayon, lahat kayo limited partner. Ang limited partner kasi, liable lang sila up to the extent of the share lang nila sa capital contributions. Oh. So kung, let's say for example, nag-contribute kayo ng tigpa 5,000, naubos yung tigpa 5,000 na yon, meron pa ring utang yung partnership. Alangan naman na hindi na magbabayad yung partnership. Merong isa na general partner na pwedeng habulin ng pinagkautangan nyo. Yun yung general partner. Kumbaga siya lahat ang sasalo kung sakaling mabankrupt or malugi yung partnership. Bakit? Para yun sa mga third persons, yung mga makakontrata nyo. Kasi kung limited kayo lahat, pag naubos yung capital nyo, wala nang habol yung mga pinagkautangan nyo. Di ba? At least kung may isang general partnership, may isa silang habulin kahit dun sa mga properties dyan na hindi niya kinontribute. Yun ang meaning nun. Kaya sa limited partnership, may isa na general partner para may isa na habulin ang mga pinagkautangan nyo. Fair ba yun? Fair yun. Siyempre, pubayag siya na maging general partner. Ibig sabihin, alam niya yung consequences na habulin siya beyond ang contribution niya. Kahit, let's say, ang contribution niya lang 10,000, nung naubos lahat ng capital ng partnership, pwede siyang habulin kahit yung sakyan niya, kahit yung bahay niya, pwede siyang habulin. Okay? Okay. As to liability, general, limited. As to duration, fixed, particular undertaking, at will. Okay? Pag fixed term, partners tayo for 10 years, 5 years, okay. For a particular undertaking, okay? Ibig sabihin, okay, sige, mag-partnership tayo, kapag mag-contribute tayo ng tig 10,000, bilhin natin ng lotto tickets. Kapag nanalo tayo, maghati-hati tayo. Once na nanalo na kayo, tapos na yung partnership. Terminated na yung partnership. Particular undertaking. Okay? Partnership at will. Wala kayong finix sa contract na 5 years, 10 years, wala. Ibig sabihin, anytime, pwedeng ma-dissolve or ma-terminate. Pwedeng next week, next month, ma-terminate na. Okay? Fixed, particular undertaking at will. Legality of existence. De jure, de facto. De jure, ibig sabihin, existing in law and in fact. Ibig sabihin, legal. Okay? Yung mga sinabi natin kanina, kapag may real property, kailangan mong sundin. PIS, public instrument, inventory, sign. Kapag 3,000 or more, public instrument, SEC. Kapag limited partnership, certificate, under oath, SEC. De jure yun, kapag na-follow yun. De jure siya. Kapag de facto, existing in fact, ibig sabihin, hindi siya na-follow. Dun sa real property kanina, kapag may contribution na real property, walang public instrument, or walang inventory, or hindi na sign, maging de facto siya. Okay? Okay. As to representation to others, alam nyo na rin to kasi na-discuss na rin natin to. Ordinary partnership, there is partnership between the partners and two third persons. Second, partnership by estoppel, yung example natin kanina. Walang partnership, pero ang representation ko sa ibang tao, may partnership. Partnership by estoppel. The last, I think this is the last. Okay, last one. Kinds of partners as to liability. Na-discuss na natin ito kanina. General and limited. Kung general, pwede siyang habulin beyond sa contributions niya. Kung limited, doon lang siya mahabol sa contribution niya. Kung nag-contribute siya ng 5,000, Naubos yung 5,000, wala na siyang liability. Kung general, nag-contribute ng 5,000, naubos yung capital, yung 5,000, pwede siyang habulin sa separate property. As to contribution, may capitalist, industrialist, may capitalist, industrialist. Capitalist, capital. Ibig sabihin, nag-contribute lang siya ng money or property, capital lang. Industrialist, nag-contribute lang yan ng industry, skill, or service lang. Yung dalawa, capitalist, industrialist. Okay, alam nyo na yan. Others, meron tayong managing partner. From the word itself, siya yung nagmamanage. Liquidating partner, from the word itself, siya yung nagli-liquidate. Meron tayong nominal partner. Ibig sabihin ng nominal partner, hindi siya partner, pero pwede siya maging liable sa partnership. Siguro kasi ginamit yung pangalan, nominal. Okay? Ostensible partner. Ibig sabihin, ostensible, kilala siya sa public na partner kasi ginamit yung name niya sa partnership. Name. Tanda na sa partnership name. Ibig sabihin, gaya sa mga CPA, sa mga lawyers, kapag ginamit, let's say for example, yung apelido mo, say for example, Lingan Law Office or Lingan and Lingan Law Office, mga ganun, pwede kang maging liable. Okay? Secret partner is a partner siya talaga. Pero, nakatago sa public. Ibig sabihin, hindi alam ng public na partner siya. Secret lang. Pero partner siya talaga. Silent naman, partner din siya talaga, pero hindi siya nakikialam sa business ng partnership. He does not participate in the management of the business. Ginagawa niya lang, nag-receive lang ng dividends or ng profits. Dormant naman, ibig sabihin, combination ito eh. Combination ng secret at silent. Ibig sabihin, hindi siya nagpa-participate sa management, at the same time, hindi din siya kilala ng public na partner siya ng partnership na yun. So, yun. Manages, liquidating, one who is in charge of liquidating. Nominal, hindi siya partner talaga. Ostensible, liable siya as partner kasi nga pinayagan niya yung magamit yung name niya sa partnership name. Secret, partner, pero hindi kilala ng public. Silent, partner, pero hindi siya participate sa management ng business. Dormant, combination ng silent and secret. Ibig sabihin, hindi siya nagpa-participate sa management at hindi rin siya kilala ng tao as a partner. Okay, so that ends our first topic. Meron ba kayong question? Wala naman. Okay, so it's 7:29. Let's conclude our discussions. I will give your learning task and assess and participation after this. So i-give ko na siya mamaya. Pwede nyo na siyang sagutin. I-recommend ko mas maganda sagutin nyo na siya kasi fresh pa para hindi nyo na babalikan. Okay? So thank you everyone. Good night.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you po.
Thank you, sir.